We're going to talk today a little bit about the Family Medical Leave Act of 1993. This particular act, the Family Medical Leave Act, was enacted to protect employees who are needing a temporary leave of absence from losing benefits or employment due to the following things. So, for example, let's say there's someone who needs time off to take care of a personal serious health condition, or care for an immediate family member with a serious health condition, or to care for a newborn baby or newly adopted child. This act specifies that employers must allow employees 12 weeks of unpaid leave to deal with these situations if they've worked there in a 12-month period. So in one 12-month period, in 1 year, they get 12 weeks of unpaid leave to cover a serious health condition for themselves, care for an immediate family member with a serious health condition, or care for a newborn or newly adopted child. And what this says is that if there's someone who has a personal problem, a family problem, or a child problem they need to deal with, the employer then cannot say, well, look, you're going to be gone for 4 weeks and we need this job done, so it'd just be easier if I fired you and hired someone else. The Family Medical Leave Act in 1993 basically said that employers who employ at least 50 employees must protect that person's job. So they are allowed this time away, this 12 weeks per 12-month period, to deal with this situation, and then at that point they're allowed to return to their position and resume their job. Now there are some stipulations. Someone has to have been employed for 12 months prior to the 12-month period where they get the 12 weeks of unpaid leave, so you've got to be there for a year, and within that 12-month period they must have worked a minimum of 1,250 hours within that 12-month period. So if they meet those two requirements, have been there for a 12-month period prior to the request for leave, have worked a minimum of 1,250 hours during that 12-month period, then the employer of a business that employs 50 employees or more is required to grant up to 12 weeks of unpaid leave to that employee, knowing that when they come back, they get their job back, and while they're gone, their health benefits cannot be negated or removed. So the health insurance must be continued, their job is protected, they can come back to it, but if they have a serious health issue for themselves, their family member, or there's a new child in the home through adoption or birth, they have the freedom to say, okay, I'm going to need to be away for a while to take care of this, but then I'll be back, and the employer must return them to their job. There are two things to remember down here, that private companies have to have a minimum of 50 employees. However, public agencies and educational institutions have no such lower limit. They must give this protection to their employees. So if they're a public agency or an educational institution, then they must provide the protection provided by the Family Medical Leave Act, once again passed in 1993. The important things to remember are there has to be a personal serious health condition, an immediate family member with a serious health condition that the employee is required to care for them, or the immediate care necessary for a newborn child or a newly adopted child. No health benefits can be removed, and they must be returned to their job. They cannot be fired in that time because they needed to be gone for these issues.